Happy New Year, everybody. We're so glad to be back. Aquí como los locos, hablando y esto y lo otro, but no estamos crazy, no estamos locos, because this...
Some may have a different opinion, but bueno. All joking aside, this is a good episode.
Yes, this is an episode that you cannot miss. Come on, guys. This is one of those that you gotta like, comment, share. You're gonna go all over this. You know why? Because this is about guardianship. And this is an important topic for all special needs. Not just, we geared it towards, autism and all of that, right? But this is all across the board for special needs. Mm-hmm. So,
it may even help people with an elderly parent.
So that too.
That applies to anyone that you take care of.
Yeah, so we're with Carlos Aguila. We're going to be with Carlos Aguila from Aguila Law. He's going to share all his information. So if you have any questions, if you want to talk to him further, if you want to start the process with him, whatever it is, he's more than willing to talk. He's super nice. Mm-hmm. And we're so grateful that he was able to do this with us.
We are. It's just, it's so much information that that we are going to need eventually.
Yes.
Anyone who has a child with special needs or even a family member with special needs.
Yeah, it works out for, the older people that we take care of, special needs, whatever it is. These are documents and information that we need to have in place because you never know.
Right.
And it's good stuff. Let me tell you.
It is.
Let me tell you. And hey, listen, for all of them out there, all of you out there that say, oh, I got time.
I thought I had time too, and it creeped up and right there. 18 was just a few months away, and we were going through other stuff, and the time really, really flies.
Yeah, it does fly. And the more you know, the better you can make decisions. So.
Yes, indeed.
All right, so here we go. I'm so excited.
I am too.
I love it.
Love it. I hope you guys do too and enjoy it and get lots of benefit from this video.
So here we go. Carlos Aguila from Aguila Law. Here we are, guys.
Good morning.
Good morning. Good morning again. All right, we're here with Carlos Aguila, right?
That's right. Good morning.
Carlos, you don't know how much we appreciate this.
Yes. And how much is needed. Although we don't have a lot of followers, we do have a lot of friends that are in similar situations and that are going to definitely benefit so much of this. I know that when I did guardianship a few months ago, I was completely blindsided by, I'm still learning stuff about guardianship. And there's just so much that you don't realize that goes into this.
Yeah.
So this is going to definitely help a lot of people.
Yeah. Yeah. And sometimes when you get the diagnosis, early on, you don't see yourself at 18 saying, oh, but I need this, really?
I know that for myself, I put off being, because there was always so much to do. I put off being very educated on guardianship because, we still have time.
Right.
We still have time. Well, last year, 18 was getting close and my son went into the hospital 10 times. And that was very alarming to me because I thought, oh my goodness, what if 18 happens and we are in the hospital? And, the medical community hasn't been great with us. That's a whole other video, but we've had a lot of problems. And so, it kind of creeped up on us.
Yeah, it did.
And it does with a lot of families that they don't realize how close. You can't just learn about this when 18 comes. You need to be aware before that time comes.
Yeah. And with that, we're going to get started. Yep. So first question, and you go roll with it.
Yeah.
What is guardianship and why is this so important?
So first, thank you for having me. I'm really appreciate being here, and I'm happy to share and educate, provide information. What you just said is exactly been my experience. I've seen that there's there's a lack of education out there, and parents are very concerned as to, what are their options as their child approaches the age of 18. So I'm happy to be here and happy to provide information. So guardianship, what's guardianship? Guardianship, it's a legal proceeding, it's a legal process where someone, typically a family member, is able to petition the court to become the advocate, the person, the voice for someone that can't or can no longer care for themselves, or can't care for themselves. They can't make decisions regarding their medical or their financial. And so it's a court process. It's a way for the court to be able to appoint someone that can have the legal authority, the legal ability to make all of those important decisions for someone that can't do it for themselves.
I run into, I've had conversations with other parents, and it's almost like it really hits you because you feel like, well, I've been making decisions all this time for my child. I suppose I am the one that's going to continue making decisions, right? But it's not the case. It's,
Right.
Legally, it's, you have to do this.
Yep, that's a common misconception, right? Parents think like, hey, I've been advocating for my child since the day that they were born. Of course, I'm going to be able to advocate for them after the age of 18.
Exactly.
But the reality of it is, you can't. Prior to them turning 18, you have natural guardianship over your child. So that's why you're able to make all the decisions for them, right? Their medical, their financial, where they go to school, what
Right.
social environments, what parties they can go to, right? That's all under your control, and you can do it legally because you have natural guardianship. But after 18, you can't anymore. It goes all of their rights. They get them, right? They receive all of their rights, and they are in control of their decisions at that point.
When is the best time to start the process, and how long, pretty much, give and take, how much does it, good question, take to do all of it?
So I always tell families, if you have children, regardless of whether they have a developmental or intellectual disability, you should always be planning for them. So I always say start as early as possible. And what I mean by that is develop a plan, develop an estate plan. Okay, and
Right.
with estate planning, there's a variety of different documents, and they play into guardianship and alternatives, and we'll talk about that. But as a mom or a dad with children, it's kind of tough to talk about. You don't really want to even think about it.
Right.
But God forbid something were to happen to you and your spouse simultaneously, right? Either incapacity, just even something like an incapacitation. Who is going to step in for your child while they're under the age of 18, right? And then even in the worst case scenario, which no one wants to think about it, but sometimes we just got to plan, right?
Right.
God forbid something would happen that both of you pass simultaneously. What would happen? Well, you can prepare a plan right away, right? You can do that by setting up, pre-need guardian, or, already set up. You can have a designation that something were to happen. We've already chosen somebody.
Okay.
And the same, like if you're an incapacity, you can have like a healthcare surrogate ready to go. You can have a durable power of attorney ready to go in the event that something were to happen if you're incapacitated. And then that also provides, it provides also peace, because if something were to happen, family members, I'm sure, are going to want to step in. But if there's a framework already there, there's a plan already in place, then you're set.
It automatically,
Right.
Yeah, you have it written down. Your wishes are written down. So I say begin there always, right? But when we're thinking about our child already nearing the age of 18, right?
Right.
It's a lot of it depends on the individual themselves. This is a very, very much an individualized approach. It's not a one size fits all.
True.
So
Right.
yeah, and that's the situation, right? So if we're talking about an individual, a child that has some decision-making capabilities, right? They're not necessarily like a full guardianship candidate, then there's different options. Um, there's a estate planning documents that we talked about, like durable power of attorneys, the healthcare surrogate, those sorts of things. And then there's also the guardianship advocate program, which is, it falls under the guardianship. It's a type of guardianship, but it's a least restrictive alternative to guardianship.
Mhm.
That process can begin actually when your child is 17 and a half, so 6 months before their 18th birthday. You can
Oh.
begin the guardianship advocate process. If they have decision-making abilities, like to sign legal documents, right? If they can understand what they are and what they're giving up, that would be done after they're 18. But if we're talking about a full guardianship, then that would be started after they turn 18. So that would be, but it's really like it's very child and individual specific. So if you feel, and mom and dad, you're the ones that know your child the best.
Right.
So if you feel like you know your child, if you feel like you're looking at maybe a guardianship or one of the alternatives, and you're approaching that 18, then start reaching out, start talking to people in the community, professionals that advocate, that work in this community, to start learning and becoming educated. But that's more or less when you want to start the process of thinking about these things.
And when you say that you could start at 17, specifically is just for that one. Power attorney and everything else is already 18? Is that what I understood? Okay.
Yeah, because when they're under 18, you're still making their decisions.
Correct. Okay.
Right? You don't need any legal documents in place. You can still go ahead and make those decisions for them. But for guardianship advocacy, that would be, you can start as early as 17 and a half, basically. You can start when they're 6 months away from their birthday.
Okay, good to know.
Okay, good.
That's great for you to know.
Yeah, I know.
In your situation.
In our case, she already went through it. He's 18. She went through it. She has to get full guardianship because he's, on the lower end of the spectrum, nonverbal, cannot make decisions on his own, et cetera, et cetera. Okay. In my case, my son is a verbal, but still, when I've seen the list of the rights that are taken away or keep or take away or whatever it is, and I'm like kind of torn myself, as in, okay, maybe in the future he can make these decisions, but seeing him now 17 and a half, I know that that's not going to happen, right? So when I've talked to other parents, it's like you have to have a very real expectation of this and a real thought of this, because I know that this is a process and it's also costly, right? And sometimes people say, well, I just get a power of attorney, I'm done. So with that said, what is your best advice on trying to figure out what fits for your child?
Yeah, so definitely we need to be thinking about our children. Obviously we want to do what's best for them, and we want to make sure that we're putting the right legal documents in place and exploring the right options. We should never be thinking about it like, well, I'll just get a power of attorney and that'll resolve it. That's how I personally see it. This is important. This is our children that we're talking about. We're not talking about some other thing that maybe we can kind of, do something a little bit, kind of go around the traditional way of doing something. And no, this is our children. So let's make sure that we're doing, we're exploring the right options and we're putting the right plan in place. When it comes to, the different options, the legal documents. So a legal document is only valid if the individual that's signing it understands what they're signing. They understand the nature and the consequence of what they're signing.
Yeah.
That's
It's not the same thing that they can sign their name and they can
Right.
sign and
Yeah.
understand what they're saying.
Right.
There's two different things.
Exactly. Signing the name is not the same as understanding what you're signing and what that represents.
Right.
And I just think that a lot of parents are very mistaken when they say that they're able to just do a power of attorney, because the child may not actually understand what that even is, and then that would not be the right way to go in that case. It wouldn't be valid.
correct. It's legally invalid. That's 100% right. It absolutely means nothing if they sign the document and then you try to present that to a service provider or to somebody that actually cares. They're going to look at that and they're going to say, did they don't have capacity to do this, right? So it is legally invalid if they don't understand the nature and consequence of what they're signing, which means they understand they're giving up all of their rights to make medical decisions, to make financial decisions, and what that means. That means mom controls, how the money is spent. Mom or dad, controls the treatments, the therapies, all of that. That's They need to understand that. If they don't understand that, then it's legally invalid.
Talking about the rights that you look into or that you take off, or talking about a full guardianship, right? Let me put my glasses on because I can't see. I printed out something from online, and there's a list of certain things that you remove or leave, as is. And there's the right to marry, to vote, to travel. There's quite a few. Apply for government benefits. What are the ones that are like specifically for full? And then when you talk about partial, because then, like I said, in my case, I'm still debating whether I'm going to do full or partial, right? So what are the things that you can take away on a partial, and what something that you really cannot? What I'm trying to say is that if there's something that, whether it's in a partial or in a full, it has to be there.
Right. So when you're talking about the full guardianship, that's the plenary guardianship. That's the guardianship of the person and potentially of the property.
That's what we have.
Okay. All right. Perfect. So that exactly. So that is the traditional guardianship where all of the rights are removed. And the list that you went through is what's outlined in the statute, right? So the right to marry, to vote, to apply for government benefits, to have a driver's license, to travel, to seek employment, to contract, to sue. These are all of the ones that are removed, right? But not every right so Florida recognizes rights that are delegable and non-delegable, meaning these are rights that can be removed, but they can't necessarily be given to the guardian to exercise on behalf of the individual. Okay, so there's delegable and non-delegable. The non-delegable rights are the first ones that you were talking about, right? The right to marry, the right to vote, the right to personally apply for government benefits, to travel, to seek employment, to have a driver's license. These are rights that cannot be taken can be taken, but cannot be given to someone else, a guardian, to exercise on behalf. So, like, the guardian can't vote for.
That makes sense.
The guardian can't travel, right? The guardian can't, get a driver's license.
Or marry them off to somebody.
Exactly. Right. Correct.
Makes sense.
Those are the ones that are non-delegable. The ones that are delegable are the ones which are to contract, the right to contract, the right to sue and defend lawsuits, the right to apply for government benefits. All of those are the ones that can be exercised by the guardian.
So those I see here, as you were saying, contract, sue, apply for benefits, to manage property.
Right.
Okay. determine the residence and consent for medical. That to me, that one is like a big one for
Right.
me. To consent on medical and mental health treatments and decisions about social environment.
Right.
So
So
those are the ones that kind of you can take or
Well, that if the right is taken away, the person who is delegated to, or the guardian, would be able to
make those
make those
decisions.
decisions.
Right.
exactly. So your scenario, like just from what I've heard so far, I mean, obviously I would need to learn a little bit more, but it sounds like you may be someone that would that your child may benefit from the advocate program, right? Where it's not the full guardianship, like the traditional plenary
Right.
guardianship, but it's one where, they preserve as many rights as possible, and it's typically the non-delegable rights. So the right to marry, the right to vote, the right to travel, all of those are rights that stay with your child, and the ones that you receive to exercise for your child are to contract, to sue, to determine medical treatment, determine where to live. Those are the rights that you would be able to exercise.
So on a
So when we're
partial, you can take, the second part of what we were talking about, the contract, the sue, the apply for benefits, you could take those away, but still leave to marry, to vote, to, apply for benefits and all that.
so okay, so there's plenary guardianship, and then there's a limited guardianship. Limited guardianship is when the individual retains any right, like any single right of all the different
Any
rights.
of
If they
them.
get one, yeah, if they retain one right, it's a limited guardianship. But when we're talking about individuals with a developmental or intellectual disability, if they fall under the statute for guardian advocacy, then we're talking about them beginning. We always want to start with preservation of rights, right? We want them to have as many rights as possible. So typically what we see is they maintain all of the non-delegable rights, and then the rights that are delegable are given to the guardian advocate.
Mm-hmm.
Okay.
Okay.
Makes sense.
Now, with all this said, whether it's a full, a partial, power of attorney, whatever it is that you have in place for your child, God forbid something goes wrong, they go into crisis, things go bad, and they're not getting any better, or things get really good and he's developing perfect and he's understanding more. Either or, it could go either way, right? Do you have a way, like, can we change, and can we adjust? And once you have it in place, that this is like a two-part question.
Mm-hmm.
Once you have it in place, is that it? Like, do we leave it as is and we don't have to do anything else until something happens? What's the process there? What's the way to go?
Sure. So the answer is yes, you could adjust, and yes, you can change, right? So, we like to always start off with the least restrictive alternative if it's appropriate, right? And if we see that that's not working, then we can kind of, increase in what we're, the legal options that we have.
Mm-hmm.
But yes, so let's talk about the durable power of attorney and the healthcare surrogate. So you need to have durable power of attorneys for financial decisions, okay? And the healthcare surrogate is for medical decisions. So if your child is able to, properly sign those documents, they can understand what they're signing, and they're legally valid, then perfect. Then you get that's an excellent option, because you have the ability to make financial and medical decisions, and you never need to get involved in guardianship. The downside to that is sort of what we're talking about. Can it be changed? Can it be modified? And the answer is absolutely yes. So suppose, they do it with mom and dad, and now, maybe mom is the the ability, that has the power of attorney to make the medical and the healthcare surrogate to be able to make medical. If something changes and they decide that they want to give it to somebody else, they can do that. It's revocable. Okay.
Okay.
It's possible that maybe someone that doesn't have their best interest at heart, someone maybe that says, hey, I want to do it, I can make the decisions for you, and maybe someone we don't trust, they can go to an attorney and have the attorney revoke the power of attorney, revoke the healthcare surrogate, and give it to the other person, the person that they want to now have.
Okay.
So those things are revocable.
With power of attorney, when you have that in place, right? Everything is the same, no changes. Do you have to renew? Do you have to make, some type of process, in a certain time frame or anything like that? Is that power attorney all done and it's all good forever if needed?
Yeah, generally, yes. Yeah, it's once it's executed, once it's done, that's it. It becomes effective from the moment it's signed. You don't need to necessarily revise it or amend it. And I say that, it always depends, right? If something
Right.
changes in the law and it needs to be updated, it's possible. If maybe the power of attorney doesn't have all the different doesn't have the things that you need in it. Sometimes they're not drafted properly, and so it may need to be revised or amended or redone. But generally speaking, no. Once it's executed, it's effective, and you have the power to make the financial decisions. And then with the healthcare surrogate, which is a separate legal document, same thing, right? Once it's signed, you've got the power. You're able to make the medical decisions, and you always want to have both. So if your child's a candidate for those documents, it's both. You want to have the durable power of attorney and the healthcare surrogate, because you can make financial decisions, but you need to make medical decisions. And a lot of times, almost all the time, the medical decisions come with financial obligations.
True.
So you need to have the power to make both decisions. So yeah, so that's
How about for guardianship? So guardianship is a little different, right? When it comes to the maintenance, I guess, of it.
That's correct. So guardianship is a court supervised process, and the court will continue to evaluate it. In fact, once the guardianship is established, you have to initially file an initial plan. You have to prepare an initial inventory, and then you have to update that annually. So every year, the court can review it and ensure that that it's being handled properly, that there aren't any significant changes. So yes, it's very much a court supervised process, and it's always the court is always looking out for the individual. It's always in the best interest of the individual. So it's going to continuously be evaluated.
I know that when you first do the guardianship, right, they do a whole evaluation. They speak to the child, they speak to you. You have things to, paperwork, here, there, and everywhere. Is that once it's reviewed again, and you say it's yearly?
Yes, there's an annual. Well, what you're talking about is an incapacity determination.
Right.
Okay, so when you have the traditional guardianship, the plenary guardianship, there's two petitions. There's a petition for incapacity, and then there's a petition to appoint a guardian. The petition for incapacity, what that involves is the court sending out actually an evaluation panel to determine whether or not the individual is actually an individual that should be declared incapacitated.
Right.
That once that declaration has been made, then that's been satisfied. Then but with I should mention, with guardianship advocacy, there is no incapacitation determination. So that's one of the benefits, right? You don't have that. If your child is a candidate for it, it's great because there is no incapacity determination. But yeah, so that part of it is not continuously evaluated. However, if the individual gets better, if your child gets better, if there's an improvement, then yes, you can file what's called the suggestion of capacity, and then the court will
Okay.
evaluate it. And if it's determined that the right should be restored, then they're going to do it, because we're always looking to preserve rights. Like we want as many rights as possible to be preserved. So certainly, if that's the case, yes, it can be done.
So that part doesn't get reviewed yearly. It's just the guardianship part.
The evaluation panels does not happen yearly, correct? It's just what's being reviewed. If there's a significant change in their condition, in their health, that's obviously going to be part of your annual reporting. You have to put that in reporting for the court to evaluate. But in terms of the individual is not being continuously determined incapacitated every year.
Yeah.
That's not. It's that.
Once that is done and said, it's done.
Right.
Then guardianship is the one that needs to be reviewed.
Right. On a yearly basis.
Correct.
On a yearly basis.
Exactly.
Okay. So gotta ask this question because people want to know.
Yeah.
How much is all of this?
Or I mean a frame, more or less.
Give us a frame.
Yeah, because people should have their own pricing when they contact you. Like you should be able, you go through that on an individual,
right,
case by case.
But more or less, what
in the ballpark?
What are we talking about with the guardianship, with incapacitate, all of that? If you do only a power of attorney, these yearly checkups or reviews, do you have to pay again? All of them.
There's some fees attached there.
All the fees to,
right,
more or less,
right. And I hate to say this, but
we're not going to say $9.99.
No. And it's a very lawyerly response, but really it depends, right? And it's really hard.
I get that.
So it's individualized. If we're talking about estate planning documents, which are the power of attorney, the healthcare surrogate, that's obviously going to be the most cost effective option. If you're just looking at something like that.
I have a question with that. Sure. You need a lawyer, or that's something that people can kind of do on their own? The power of attorney and those type of
I wouldn't. I mean, there's so many things I can do on my own, but when it comes to the likelihood of my child or like those type of things, I'm gonna
but there's people that want to kind of
so I mean, you can go to different places and buy forms, right? Like there's form documents. The thing is, like, those form documents don't come with any legal advice or legal discussion. And this is something that's very, very individualized.
Yes.
So yeah, you can print something out and do some sort of form. But in fact, the courts have talked about this, and it's been developed over the years, where it's sort of, those forms cannot come with any legal, legal advice or legal explanation as to anything. So, you're sort of on your own when it comes to that. You definitely want to have it done to ensure that it's valid. You want to have it done with an attorney.
I agree.
And not only that, practitioners that are dealing with working with individuals with developmental or intellectual disabilities, a lot of times before even having those documents executed, they're going to, make sure that, that they have the ability to sign these documents. And the way they typically do it is they'll talk to the family doctors, the healthcare providers, and actually see, does this individual have the capacity? A lot of times they'll have them sign a document saying, yes, I believe that they do. And usually it's to multiple providers, right? Just to kind of get a feel. Maybe one says yes, but another one says no.
Right.
I don't know.
And if it's sort of that split, then it's kind of like, the attorney probably is not going to feel comfortable having a durable power of attorney executed. Remember, the client is the individual, is the child. So if you come to my office and you want to discuss that, really your child is going to be my client, because it's your child that's giving up his or her right to give it to somebody else.
Correct.
Right. So a lot of times parents don't think about that. But to answer your question, yes, you can go get a form and do it that way, but I would, I don't recommend it.
As someone who just did it and actually had to borrow the money from somebody to be able to do it because we needed to do it right away, I would definitely recommend it. I've done a lot of things on my own that people would suggest that I didn't do on my own, and they worked out fine. But this is very intricate, and this is our children.
Yeah.
And so much is at stake, and I don't want to leave it up to LegalZoom or whatever. Like,
Exactly.
Yeah, no.
I need a human.
Yeah. So,
Yeah, but I asked that question.
I mean, I
because
get it.
There's people that say, no, those
Mm-hmm.
the forms are there. I'll fill them out. I'll come make a few phone calls and just, So
Yeah, this is definitely something that I was not even. There was no way I was going to even attempt
right.
to.
no, I mean, listen,
even if I knew how to do all of it, I know.
what, lo barato sale caro, right? Like,
Exactly.
and you don't, then that's sometimes we kind of like, we take that risk, but we're talking about our children, right?
Our children.
Exactly.
This is not
Absolutely.
a situation where we want to be doing some form that we found on some template online. I mean, that's my opinion.
And with the power of attorney, going that route, the fees are much less than a guardianship, right?
Sure. That's going to be the most cost effective, option. Again, if your child is, a candidate for that, if they can understand it, awesome. That is the best, right? But, again, you got to think about that they're revocable. So,
right.
We've had, situations where, the son has fallen in love with someone that maybe doesn't have their best interest, and so it can be a situation.
Yeah, because
I mean, deal with down the road.
That makes sense. If supposedly they signed off on it, they can sign off on it. Like, right? Yep. If that makes sense.
That's right. That's
I'm giving you the authority. Right. I can take it away.
That's absolutely true. Exactly. So that, there's those documents. The advocacy is really like the best option if your child is a candidate for it. I mean, generally, right? This is all very individualized. It is the least, under the guardianship, when we're talking guardianship, it is the most cost effective. There is no incapacity determination, which is a huge savings. It's only one petition that's being filed. You're not filing the petition for incapacity. You're filing just the appointment of a guardian advocate. And so even like for the reporting, the annual reportings, if they don't have significant money, if they don't have property or stuff, then you can actually a lot of times you can ask the court to waive the annual accounting requirements if it's only like social security income or something like that.
Right.
Good. Okay. So, that makes sense. Yeah. Now for guardianship, I know that's costly, and with depending on what kind of guardianship also that has to do with that, right?
Yeah, it depends on the type of guardianship. It depends on, there's expenses, there's the filing fees, remember when a guardianship is initiated, the court is obligated to appoint an attorney to represent what they call the alleged incapacitated person. There's a cost to that. There's a training course, which also you have to do that for advocacy as well. But there's all sorts of fees that are there that need to be considered. They're all really designed to safeguard the individual that's going through the process. The attorney that's representing the alleged, what they call it, the AIP is what they call it, the alleged incapacitated person at that point.
Right.
They're there to make sure that their voice is heard, to make sure that that they're advocating for them, making sure that they can preserve as many rights as possible if that's the situation. And then you have to sit through like an educational course as well to make sure that that you're doing what needs to be done as a guardian or as an advocate. So it's why I say it's hard to tell you like, honestly any attorney that tells you no, I can do it for X amount of money without even knowing you or without being able to understand the situation.
I would see that as a red flag, to be honest, and it's probably not going to even be that.
I mean, I asked you kind of like a ballpark, like more or less,
Right.
because there's people that ask outrageous
Yeah.
amount of money.
Right, right.
That it's nothing. I mean, knowing what she went through,
Mm-hmm.
and hers was
Right.
much, elaborate, right? And then you hear, the amounts. It's like,
And in
no.
addition to which, a lot of people don't realize as well, it's not just the court-appointed attorney and like all of those fees attached as well, but the professionals, the medical review, I don't know what they're called, but they need to be paid as well. And
That's right.
so
the people
that declare them that agree to the incapacitation, it's usually 3 doctors if I'm not mistaken, they need to be paid as well. They're not working for free. So in the sense of, in our case, basically what they asked me is there was no property, there's no assets, he has no income other than Social Security. So he qualified for everything to be like waived, I guess, or paid by the courts.
Right.
But if he has any money in his savings account, or if he has any money to his name, we would have had to pay for that as well. Then that would have been paid as well. Is that correct?
That's right. That's right. Exactly. So that's always something that we look at. If we can, we try to apply for what you're talking about, so that they can have all of those costs, sort of waived, right? If they don't have significant assets, then we can do that. There's a process for that. But otherwise,
this team supposedly works for the child in question, the person that represents them.
Right.
Right. And remember, we're thinking about this in the context of our children, that have a disability, a developmental or intellectual disability. But guardianship really extends to usually we're talking about, like the elderly, and they want to make sure, they want to make sure they're not being exploited.
Yeah.
So sometimes, elderly people that are starting to have diminished capacity. Maybe somebody wants to come in right away and try to get a guardianship, and maybe they don't have the best interest at heart. And so the court wants to put these safeguards in place to make sure that if we're doing this, we're being very careful about it. We're analyzing everything about it, and we're going to make sure that they have a voice. They're going to have an attorney. They're gonna have all of these safeguards in place so that this administration isn't done, or the guardianship isn't established without ensuring that it is necessary. And that's really how how practitioners in this area look at this, right? We have to always look at, is it necessary? If it is, what is the least restrictive alternative? And then we take it from there.
Perfect.
Like I said, in my case, I'm very torn because, like at this point, he has been able to hold a job. He does like 2-3 hours a week. It's not right, but it's just starting. I'm going through vocational rehab, but he goes to these places with someone. He doesn't go by himself. He goes with a therapist, and so because he needs to be kind of like, it's not about helping him do the job. It's just basically like guided, like, don't get up, finish up, just kind of like
reinforcing,
reinforcing the good,
what's expected in a job. He needs that person there.
Right. So if I take the right of employment, then he cannot do these programs.
Have those accommodations of having the therapist
right
there,
and then I went through a Zoom meeting for FIU, the Embrace program, and they explained that if a child has full guardianship, they cannot be in the program. And it's like,
that's right.
Okay, so then, so these are things that in my case, he's not high functioning, he's not low functioning. He's kind of like somewhere in the middle.
Honestly,
that if I take certain things, then I'm kind of tying his,
I think that in the coming months, you all should meet. So that, that he can really give, we can really go through your particular situation and case and get to know, because I'm sure that like you said, everything is individualized.
It's just kind of like
To make the right decision.
but I feel like you have to make a realistic decision.
Mhm.
Absolutely.
You cannot
Absolutely.
just go ahead and just, no, pero él puede, hacer esto, hacer lo otro,
Mhm.
let's just do it. Or take everything away and then just kind of tie his hands of, what he can do or not do.
Right.
Or possibly can do, right? So it's
so
very conflicting for some
Mhm.
parents because
Right.
once in her case, is a no-brainer, right?
Right.
She had to go ahead, do it,
Right.
done. But, with certain parents to be able to,
And like the rights to marry and sign contracts and all that stuff, I wasn't worried about that because he's not going to do any of. Nobody's going to lure him to do that because he doesn't know what any of that is. But
right.
there's a lot of fraud,
yes.
and
Oh,
there's
yeah.
a lot of like bad people that get a hold of your social security number or your name, and I'm like, I don't want them for him to be a victim in these type of cases either. So it was definitely it was the right way to go for us.
Yeah.
I
The
think
With parents that are divorced, what have you seen, like the dynamic of that and how
would that work?
rights, are determined?
We have a lot of people that will be interested in this.
Yes.
sure.
'Cause there's a lot of single moms,
Mm-hmm.
and then, they do most of the decisions, most of the,
Right.
the ins and outs of
Right.
every day. And then this moment comes, and then it's like, okay, it's a tug of war here.
Right. How do we deal with that when there's a divorce and maybe one parent is the custodial parent
Got it. Yes.
and the one that
So
does essentially everything?
we'll talk about that. I just want to address what we had just mentioned. So you know about that guardianship advocacy may be that option that fits sort of that middle ground for you, because
I believe so
it
too.
does, you don't take away, like, he can continue to work. That's his right. Your child will be able to work, continue to be able to maintain all of the non-delegable rights, which is excellent. When that statute was created, it was created with that in mind. This is generally for individuals that have some, decision making abilities. They're not necessarily on one side of the spectrum or the other. It's sort of like,
Right.
It's a great option because you're able to preserve a lot of the rights. So that might be the solution in that sort of a scenario.
Yeah, I agree. He's already showed some interest in being involved in certain decisions regarding, whether it be like, therapy hours or like where he works, because the way that the job thing works is that it alternates. He's not at one place forever. It's like a 2 or 3 month, right?
It's like a 6 to 8 week program.
So he's been vocal about what he wants or what he doesn't want.
And with vocational rehab, they do like what they call a referral. And that referral is 6 to 8 weeks. He's there. You can try another 6 to 8 weeks in the same place, but then they want you to move around, to rotate,
and he's
to another
vocal about. He's starting to show some interest in what happens and what doesn't happen. So
there you go.
That's good.
Exactly. And then the right to marry, right? So they maintain the right to marry, but you have the right to but you have the right to contract, right? So marriage is a contract. So that is something that, if it needs to be court approved, right? If it's a situation where, God forbid, it's not the right situation going on where they're choosing to marry, but it's maybe not the right or in the best interest, you do have the right to contract, so we can have the court get involved at that point if necessary.
Oh, okay. That's good to know.
See, thank you. See, that was worrying.
Yeah.
Because I've heard horror stories about kids that, she's doing, this particular girl, it was like, she was doing good. She was, she started to have a boyfriend, and this boyfriend just went.
It could be like even a catfish type of situation, so to speak, like where they pretend to be somebody that they're not to, you never know, marry and take their social security money, even if that's all they have. Like, you just really never know.
Yeah. And the guy even went and bought, lured her into.
They bought a vehicle.
They bought a vehicle. They were talking about marriage. Parents had to step in and were like, whoa, wait, hold on. So, it's tricky there.
Scary.
No, and imagine the scenario, mom and dad, now you step in to try to help, and that person says, okay, but who are you? Oh, mom, I'm dad. Yeah, but they're 18, they're 19, they're 20. Like, you have no power. Like, for a lack of a better way to say it, I mean, that's the reality of it. You want to make sure you have, if this is the situation or the solution, you want to have the solution in place. You want to have that legal document, that whatever it looks like, you want to have that in place to prevent something like that. People that want to scam, the fraud, definitely, you want to be thinking about that. But so getting back to your question about divorce. So yes, so generally, I mean, from what we've seen, it's usually it's usually one or the other. Like, either one of the parents will be the guardian. Although you can have co-guardians, so you can have two guardians, right? You can have to make the decisions. The only issue, that I see with that is if there is a disagreement over something, then you've got to get the court involved. So whenever there's a disagreement about any of these decisions, the court will have to get involved and step in, and then the court will will always do what's in the best interest of the child or of the individual. So but yeah, you can always have co-guardians, if that's the dynamic, if that can work. But
is that what you did? That's what you did?
Yes.
You have co-guardians.
She's married.
So yes, I'm married to my son's father.
Yeah, she's still married, right? But I'm divorced. So we have the two scenarios here. And is that what you did? You did.
Yes. I'm the, I guess, primary. I don't know if there's a primary, but right. And then dad would be the co. But I guess what I'm wondering too, and I mean, although this doesn't apply to me, but I know it does to many, should the custodial parent let the other parent know that it's almost 18, it's almost that time, we need to do guardianship, and involve them in that process? Or should a parent go and do it on their own? I'm asking for a friend.
She's asking for a friend.
Like, how should that be
about this? That's like I'm chuckling, but
like that, I'm sure other people would wonder that. Like, do they do this to, like, because in my case it was a no-brainer,
right?
Because we were married, and my husband is an exceptional dad, and that's how we roll. Yes. But when you're divorced, and there's different. And there's a custodial parent, the parent that, even if the other parent prior to 18 is somewhat involved and does see the child on a regular basis, and there is a schedule of visitations and everything in place, how would that come into play when it's that time? Like,
so ideally, I think, the parents need to talk. They need to know that this is something that one or the other feels is important, that needs to be done for the best interest of the child. And if we're keeping that at the forefront, right, like, forget the other stuff. If we're just thinking about our son or our daughter, that should really be the conversation. It really shouldn't be anything else. And hopefully, it's a conversation that's had that's fruitful, that you can make some decisions together on. But then, of course, if it's something that ends up being, something that maybe you don't have that relationship, and you're not able to talk to them about it, then that's obviously a lot trickier. I'd certainly recommend, I would start, by maybe talking to your family attorney, the attorney that assisted you. Maybe there's you can get with him or her and sort of begin, discussing about how we can approach this issue. But it's definitely something that, when you file a petition for guardianship and for a guardian advocate, you have to notify people. I mean, it's not something you can do hidden, right? Like, people need to be aware of it. There's actually a notice requirement. And so, imagine if someone gets this in the mail and they're like, whoa, what's going on with my child? I didn't know this. I didn't know this was happening. That's going to be a lot of, that's.
So like, let's say in my case, right now I start the process, but I don't let dad know. Or if I tell him, I say, hey, I'm starting this, and he forgets about it and he's not involved. So whatever, he's going to get a notice.
There's a notice requirement. Yep. There's a notice requirement. There's a notice requirement that has to be filed. So yeah, everybody.
So both parents need to be on the same page, and both parents are legally
right. So what happens if one just says, I don't think he needs that, I think he's fine?
Yeah. Generally, we don't see that. Generally, it's
okay.
We see like it's usually the
you know.
No, for sure.
For a friend again.
If I just hypothetical.
Because usually it's like the who, right? It's not like who is going to be the guardian, right? That's usually like, that could be more of the
that power
but
struggle.
Not necessarily, right? But I mean, you file the petition, right? If it's what's in the best interest and it's necessary, it could become contested. So they can file a petition with the court, basically saying that it's not necessary, and then that would be sort of more of a contested issue, which is not really common, but it could happen, right? There's somebody steps in and says, "Wait a minute, I'm objecting to this. This is not something that needs to be had." Ultimately, the court, as I've been saying, like, the court supervises this entire process. So that's really the beauty of it, right? The court's going to be able to analyze it, working from the framework that's in our statute. Right, that we're looking at the least restrictive alternative, the best interest of the alleged incapacitated person, or the ward if they be declared incapacitated. We're looking out for the best interest of the individual. It's not about the other people that are that have
as it should be.
Right. So you don't really need, I don't know how you would say, I guess, permission. Like, let's say if I start the process and, dad says, why are you doing that? It's not necessary, or whatever it is. I'm putting myself there, but, it could happen to anyone. So I could keep on going and doing whatever I need to do for my child, and the court will decide.
Yeah, I mean, if it's gonna get contested, then yes, the court will have to ultimately be the one to make the determination. It ends up becoming more of like a, sort of I don't know, like a mini trial, I would say, like an evidentiary issue where they're going to be analyzing everything, and it can become heated, it can become contested, and the court will ultimately decide whether it's proper or not. I mean, if it's
that will be an extra process, right?
Of course, that would be part of, like, when I said it depends, right? That's kind of what I'm talking about. Like, we never know what's going to happen.
Sure. Right.
But usually, irrespective of a dissolution of marriage situation, usually, like, parents know, like, this is something that's needed or not, right? And if it's needed, like I said, it's usually like who is going to be, not necessarily that it's necessary. That's typically generally what we see.
I think, I'm not in that situation, but I think that the best way to handle it, and that's just me, is we do a lot of Spanglish on the podcast, by the way, but is entrarle por la buena primero. Like, say, like, go in, like, positive and all that, by the way, like, from a positive, and just go in with like a positive outlook. Like, I'm preparing to do this. Just wanted to let you know, and that's, I think, again, it's easier said than done because I'm not in that situation, but that's how I think I would want it handled, and obviously if it gets ugly from there, then that's a different story, but, you got to try to go in, honest.
With a lot of stories, that I've heard, once you start saying, okay, but we got to do this, but it's this much. Pero espérate, hold on. Right. But why? and that could turn into the struggle too.
Yeah.
So I get it, trust me,
Honestly, I think
get
that in that case, even if you're not, I wouldn't count with anybody's money to do it. If they don't want to help, they don't want to help. This is
Yeah.
something that, especially being the person that's the custodial parent at that point, I would be like, this is something that we need to do, whether you help financially with it or not. It needs to get done, and it's in the best interest for the child. So, the rest is on you. You know what I mean? I think that's
Right.
those are the struggles, I
Yeah.
guess. In that case, when you have both parents or divorced parents, is there a way to do guardianship? I'll be, let's say in my case, right? I'll take care of the decision making, and then I delegate to dad financial privileges, I guess,
Yes.
or whatever it is.
Absolutely.
Or I take on both.
Correct.
Is that something that you can kind of play with?
Yeah, you can do that. You can have a guardian of the property and a guardian of the person, right? So if it's you can actually have one doing money, financial stuff, and the other one making decisions for health. You can person and property, sure.
You could kind
You
of
can do
split that.
You can split that, yeah, definitely.
Regardless whether they're divorced or together.
I mean, if you're both coming together and you're filing the petition and you both agree it needs to be done, and you want to set it up so that you have a guardian of the property being mom and guardian of the person being dad, you can set it up that way. That way it's separate, but a lot of times they
They're
mix,
together.
right? Like because it's hard to make like the example that I gave, like with medical and financial, it goes hand in hand. You can make the decision to make a decision for medical treatment, but there's an expense for that. Or if they need to go to a facility, right? Who's going to make the decision for the financial aspect of it, for the payment? Exactly. So
right.
But yes, it can be designated in that way.
You could be split that way. I asked because it's not our case, but there's people that have, wealth and money, and they do trust for their kids, and they want to kind of manage that, have somebody manage that, kind of like separate, and they have, they put all the stipulations and all that stuff. So, that may work for somebody like, I mean, in our case, no, but
Right.
for other people that may have
And
properties and money set aside.
Yeah. And there's another part of that is the different trust options that are out there. The special needs trust. A lot of times family members, they want to provide, maybe Abuela has money and she wants to leave, some money to the child, to her grandchild.
That was my next question, because tío, abuela, somebody, passed away and le dejó dinero, and then what do you do with that?
Yeah, so you can actually set up a special needs trust, which there's really two types. There's a third party and a first party. The third party, basically what we're thinking about special needs trust, we want to make sure that whatever inheritance that they receive isn't disqualifying them for maybe any public benefits that they're receiving. And you can set it up in that way. If it's money that came in an inheritance, if it's put in the special needs trust, then it won't kick them out of their eligibility.
Their benefits.
For their benefits, exactly. If it's money that they've received, sometimes they have significant money. If maybe they're involved in a lawsuit and they have a settlement, and it's a lot of money that they're receiving, and they don't want to be kicked out of their benefits, they can put that in a special needs trust in order to keep them qualified.
So that special needs trust it guards that money, and just, it doesn't kind of mix one with the other, with whatever benefits or Social Security or whatever it is that they're getting.
exactly. It was created for that purpose. It's so that, you know, these individuals, so that they can receive the benefit of trust income,
Right.
without being kicked out of their, you know, their eligibility for Social Security, for those benefits, which are, a lot of them are, you know, most of them are means tested, meaning, you know,
Mhm.
it's based on
Right.
financial need.
Right.
Right.
So that's there to protect that benefit, and that can be set up.
Is there a cap? Like,
Is there a cap in the
like,
amount?
you know, like if you get, you know, I don't know, 3 million.
You're coming into some money.
I don't know. I hope so. Girl, ¿quién se va a morir? Espérate. Ay, Jesús, por Dios, no.
um,
No, I mean, maybe, you know, if it's something like huge like that, or, you know, we're talking about 150,000, 200,000. If it's more than that, then, you know, they may be, is there like a cap, or it really doesn't matter how much money you get in
there
there?
there's I don't believe there's a cap. I don't think there's a cap on a special needs trust. It's designed specifically for that, so that there's no eligibility knockout, so you're not kicked out of your benefits. But no, there's no cap in terms of what can come into the special needs trust.
Ah, okay. So cuando me gane la lotería in 2024, yeah,
Sounds
we're good.
Sounds good.
Okay, yeah.
Question. That kind of goes with that. So in a special needs trust, if once, I mean, I never want to think that that's going to ever happen, but when the person passes, all that money that was in the trust goes back to like Medicaid or any assistance that they had been receiving. Is the special needs trust different? Because I just did want a qualified income trust for my
Right.
mother-in-law. And as
Mhm.
far as I know, from what I understood, we did it with the help of an attorney, friend, family member who doesn't really do that type of, but they kind of helped us through it.
Right.
And from what I understand, anything that's in the trust, goes to pay back Medicaid, for example.
Correct. For a
Is it the
qualified
same with
income
the special
trust.
needs trust?
With to be honest with you, that I'm not particularly
Okay.
sure on. I think that's something that, if I'm not mistaken, it's not. There is no Medicaid payback that's required.
Okay.
But I'd have to get back to you on that.
No problem.
Okay.
Thank you. I just wasn't sure if it was we don't have, again, mine doesn't have that, but I'm just wondering. Thank you. I think, did we cover everything?
I think
I
we
think
covered.
we did. I think and some. Is there anything else that you want to add that you think may be beneficial to anybody watching?
I think
I think we covered a lot.
Yeah, no, I think we covered everything. Just, ask questions. It's so important, to have that information out there, so that you can have the education, the knowledge to be able to make the best decision for your child. But thank you for
Yes.
having me. I appreciate being here. It's
Thank
been
you.
great.
We really appreciate it. And if would you mind providing your information so that all these parents that are going to be watching you can actually reach out to you?
Sure. So, I'm Carlos Aguila. My office is Aguila Law. We're located in the Dayland area. We're 9990 Southwest 77th Avenue, Suite 330, Miami, Florida 33156. Our phone number is 305-967-8554. And you can email any questions that you may have at info@aguilapa.com. And thanks again for having me.
Perfect. Thank you so
Awesome.
much. And we'll link the information as well on the video.
Yeah, we'll put it on the video, and thank you for doing this. I mean,
We really
a lot of
appreciate it.
parents, we'll put it later, but it
Mhm.
creeps up on you, and
Mhm.
it's something to be done.
Yes.
Thank you so much.
Thank you. It was so nice meeting
You're
you.
welcome.
Such great
Likewise.
information. Have a good day.
Thank you.
Thank
too.
you.
Take care. Bye-bye.
Bye. So there you have it. All the information that you need. I'm sure, there's more questions, every child is different.
Mhm.
So you have to
And it's
think.
like you said, every case is individualized.
Yeah.
no case is the same.
Yeah.
So,
Yeah. So there's different ways to go about it,
mhm.
and you got to find what's good for you.
Yes.
But have a realistic approach to it, please, because you don't want to be stuck one day that something happens, or your child's going to run off to get married, and
Mhm.
you want to stop it.
Mhm.
That's like, eso es lo que me vuelve loca a mí. Like, can you imagine?
I know.
But and then you don't have any papers. Then you can't, make decisions for him,
Right.
and stop, people that may want to do harm to your child.
Mhm.
So and lure them to God knows what. So
Yeah.
with all the horror stories, is
True.
Thank you again, Carlos Aguila Law. Again, if you wanna reach out to him, is 305-967-8554. And he already gave us his email on the video. So if you want to reach out to him or any other attorney,
Just as long as you do it.
yes,
If you have a child with special needs, this is one of the most important things that you can do for your child.
And do it the right way. I know that we may want to, kind of cut off some corners and, save some money, but and it could be pricey. He didn't give us any prices, but
it's
we get
totally
it.
expected because
We get
it's
it.
very individual.
I tried, guys. I tried.
It's very
Yeah,
individual.
But it's very individual.
The best thing to do is to make an appointment, get all your questions answered. And even if you don't choose a particular attorney at that point, at least you already explained your case to somebody. They've explained the expectations and the way that everything works. And then you can always just go to see different attorneys and until you find the right one for you. But yeah, it's just it's got to get done. And I wouldn't, like I said earlier in the video, I would not leave that to like LegalZoom or to, there are a lot of things that I've done myself that lots of things that I've done myself that I've been like, oh yeah, I can do that, and I learned to do them, and I, even court stuff. But this is something that I would not tackle myself. There's just too much at stake, and our kids are priority.
Yeah,
definitely, I wouldn't tackle this myself.
Yeah, and it's something that they do it, for every, a bunch of people, and they can give
There's
you
that experience,
the advice, and knowing, I'm sure they at one point or other they see your child, so they kind of like.
I know that, like when I did it, our attorney was like she told me what to expect, and then she said, then this may happen, and this might arise. Like we already kind of knew what could transpire during that time, during the waiting time, and during the actual, court appearance and all that stuff. So, they know they've done this.
Yeah. So you can't leave it to chance.
No, definitely not.
So thank you for being here. You know how to get us. Spectrum Mamis all across the board.
We're all over social media, YouTube, and on most of the streaming platforms as well, in a podcast. And yeah. Thank you for watching such an important video. Probably the most important.
Yes.
That we've
One
done.
of the best
that we've done.
I'm proud of myself. Are you proud of yourself?
I'm proud of myself.
We're proud of each other and ourselves. Have a good one, guys. Happy New Year.
Happy New Year. Bye.
Bye. New podcast every Friday. Bye.